Welcome to the legal aspects of relative placements, more aptly titled, Does It Really Matter How Far the Apple Falls from the Tree? I'm Jeannie Gordon, the Legal Issues Training Coordinator for the Children's Division, and I've been a child welfare attorney since 1997.
I'm Christy Collins. I'm a Program Development Specialist, and I oversee the foster care policy. I've worked for the Children's Division since 2003.
Christy and I are going to present all these legal issues and talk about the facts that are involved in placements together. We decided this might be a better way to do it. Today's date is August 31st, 2010. All your materials for this training are available on the Children's Division intranet. If you go to Practice and Professional Development and then look for the Legal Aspects DVD series, you will have a PowerPoint, the relative placement chart as a handout, and a handout that lists all these factual bases, we're going to call them factors, that we think need to be considered when you're looking at placement. The training is going to cover a couple of areas. Most importantly, it's going to cover the laws that affect placement decisions, and then we're going to talk about the need for a factual basis to support the placement decision. We're talking about information on the child, information on the relatives, how to determine if it's in the child's best interest or contrary to the best interest, or in the case of siblings, is it contrary to the safety and well-being of any of the siblings. So we're going to talk about the need to also document this factual basis for the decision making. As we go, Christy and I are going to have a conversation on some scenarios on how you apply all of these laws and the facts to particular situations. So when we talk about the laws that affect placement decisions, you're really looking at a puzzle, and we're trying to make all these little pieces of the puzzle fit. You look at the facts that apply. Is it one child or many child that were removed? What are the needs of each of the individual children? Do they have different dads? Are any of these dads fit for placement? What about relatives? Do we have the availability of relatives for placement? What about the child's needs? Do they have special needs? What about their school needs if they're a school-age child? How do all of the laws that affect these placement decisions apply to this specific fact scenario in your case? In beginning this training, we're going to start from a couple of premises. Number one, that the child is in protective custody and that the child will be going home, if possible. And the reason for that is because we know in almost all cases we're working reunification with a parent. Another premise that we're going to work from is that the child will be placed with family. Even if they're not placed initially with family members but are placed in foster care, we're still going to continue to look for relatives for placement throughout the life of the case. There is no expiration date on that relative placement law. And lastly, we're going to assume that the concurrent plan is going to be adoption or guardianship with a relative. And that's going to be the plan until we have ruled out all relatives for placement, even if the child is in a foster care placement. So the discussion on the laws and facts that are going to follow this will follow the placement hierarchy chart that you have as a handout in this case. The purpose of the chart is to put all the laws together that affect your decision making. They have statute numbers with them, and different parts of the statutes are set out, and this will give you something you can talk with your family support team members, and you can also use in talking to the courts. The placement decisions will probably always vary depending on the factual basis, don't you think, Christy?
I think so. I think you're going to have to look at the information about the child, about the parents, the siblings, and about the relatives that are involved, and then make your decision based on all the evidence that you have.
The idea behind all these laws in the chart also is when you take all these facts and you apply the law, you want to try to make the laws fit together and work together if at all possible. So let's move on to sources of the law. There's all types of different laws that affect placement decisions. They affect actually all the work that we do. The federal and state constitutional laws affect us. The U.S. Constitution is considered the supreme law of the land. So all of the rights that we are given as individual citizens and as parents are the supreme law of the land, and those have to be complied with. We have federal and state statutes. When you talk about the federal and state statutes, an example of a federal law, those are passed by the legislatures, would be the Adoption and Safe Families Act. The state statutes, also many of the Adoption and Safe Family Act statutes are also included in state statutes, as well as the hotline scheme and the relative placement chart, or the relative placement laws. The Supreme Court rules of procedure also apply, and when a case comes into court, the Supreme Court rules of procedure help the case progress through the court system, and they have the same effect as law. Federal and state agency regulations, there are federal agency regulations called the Code of Federal Regulations, and an example of that is that sets out in more detail information about how we apply the Indian Child Welfare Act. The Indian Child Welfare Act is federal law, and then what the rule does is it gives more information on how to apply that law. The same holds true for Missouri. Missouri has what's called the Code of State Regulation. An example of a Missouri regulation would be in TPR cases, there's caps on attorney fees for the parents, attorneys, and guardian ad litems in the case, unless special findings are made by the court. And that regulation is enforced then by the courts. And lastly, we have agency policy. Most of the Child Welfare Manual is based on federal and state law and good child welfare practice. So the relative placement chart actually reflects this legal hierarchy, the way the chart is set out. And we're going to talk about applying parents' constitutional rights first, and then any federal laws that apply, which will be ICWA and the sibling placements, and then all the Missouri laws on grandparent and other relative placement. The idea, again, is that all these laws, we should try to make them work together based on the facts of any particular case. So let's talk a little bit about constitutional rights and how it affects placement. The import of the constitutional rights is the L word, what I call the L word. A parent has a liberty interest in their relationship with a child, and the child has that same liberty interest in relationship to their parents. And state government basically cannot interfere without providing due process. These constitutional rights are important because we have to work with the parents. We have to provide reasonable efforts in almost all cases. But we don't want to forget that the state has a compelling interest in protecting children from abuse and neglect. We just need to remember that we can't ride up on our white horse, scoop up the child, and carry the child off into the sunset. We have to work with the parents. There are other laws besides constitutional laws that affect our dealings with the parents. And these next few slides that we're going to talk about involve the diligent search to identify and locate parents, the non-offending parent law, the prohibition on reunification and placement when there's certain criminal offenses by a parent or another in the home, and lastly, the need for reasonable efforts. So you want to take a look at the hierarchy chart. The first part of page 1 goes into detail about placement with a fit parent. The idea is that a child who comes into care, if the other parent hasn't done anything, if they're a fit parent, then we're looking at placement with that fit parent. We also have to do an absent parent search. We have to look for the non-offending parent to make sure they're a non-offending parent and whether or not they're entitled to custody and how the prohibition applies. Lastly, we want to talk, when we're talking fit parent, what we're talking, that's probably my turn, and what we're trying to talk about is it covers all kinds of parents that aren't the subject of the investigation that brought the child into care. It may include that non-offending parent who hasn't done anything wrong. We may include the non-residential or non-custodial parent. So what those terms mean may be important. When we're talking the non-residential parent, we're talking about that parent that doesn't live in the home with the child. The non-custodial parent may be that same parent, but sometimes we have to remember that there are custody orders where a parent may not have a right to visitation or custody of the child. So the bottom line is if the other parent is a fit parent, then they should be entitled to custody except when limited by the non-offending parent law, the prohibition on placement, and of course subject to background checks and a walkthrough. And I think, Christy, isn't it true, everything we're dealing with today, we're talking, it would be subject to a background check and a walkthrough,
yes.
Whether it's a relative or kinship or someone we think might be a fit parent.
Yes, that's correct.
Okay. And it comes down to what is the safety issue that would prevent the placement. So you need to think in those type of terms when we're talking about not placing with a parent. Let's move on to the diligent search law. The law requires the division to make diligent efforts to locate and identify a parent. And this has to be reported to the court at every hearing until relieved by the court. This gives the division an affirmative duty to go out and look for the absent parent and identify them.
So I need to keep looking for the non-offending or non-custodial parent until I find them. Is that correct?
Absolutely. You need to keep looking for them until you find them, or unless the court would relieve you of efforts. Do you have a social work perspective on that?
Well, I think one thing that's important to remember when doing this is that that other parent can provide a lot of family history on the child that the child might not already know. In addition, it also provides another set of relatives that we can explore. We all know that, foster homes are kind of scarce, and it would be nice for the child to be able to be placed in a community where they already know someone instead of being placed in a home with strangers.
That's absolutely true. And to finish up with a legal perspective on that is the looking for the absent parent. It may provide us with a parent for reunification, relatives for placement, and may affect the ability to do a TPR or a guardianship, again, because parents have constitutional rights. The next subject when we're talking about relatives is who's dad? What about dad? Who's dad? Dad is a very complicated issue, and it's not the main subject of this training. But we have to discuss it, I think, in some detail so we're clear about who we're placing with and what, at a minimum, is a dad.
So what if I have a person who says he's the father, but he's not on the birth certificate and paternity testing has not been done? Do I have to place with him?
I think it would be very difficult to place with that type of dad, but you and I both know that ultimately it will be the court's decision. When we're talking about a non-offending parent, we're talking about them being entitled to custody. And most of the time, when we're talking about how a parent would have custody, we're talking about their legal relationship with the child. In those cases, we're really looking at who's on the birth certificate. If a man's name is on the birth certificate, then there's some sort of law that allows his name to be placed there. And consequently, I think that gives rise to the term legal dad. And we, at a minimum, have to be working with those types of dad. Now, what about paternity testing, Christy? Don't you think that if paternity testing's been done, even if he's not on the birth certificate, if a child comes into care, the court would place with that type of dad?
Yes, as long as he matched those CAN checks, walkthrough of the home, and he was fit to take care of the child.
Okay. Let's move on to that non-offending parent. This is Section 211.037, and this kind of sets the law out a little bit in terms of if the parent hasn't done anything wrong and they're entitled to custody, then they should get placement. So what does entitled to physical custody mean? We talked a bit about it would help if the name's on the birth certificate, because at least at that point, they've got some kind of rights with the child. But lots of our parents aren't married, and there's not always custody orders, are there,
No.
Christy? So at a minimum, if the dad's name's on the birth certificate, then he should be entitled to custody. We want to be careful if parents say they're divorced and there are custody orders. My recommendation would be to get a copy of the custody order, because how do you determine whether or not they're entitled to physical custody? I would look at, do they have visitation? Are they allowed unsupervised visitation, or are they allowed periods of custody? In either of those cases, I would say they're entitled to physical custody. But once in a while, we have court orders that say this parent is not entitled to physical custody or visitation. And in those cases, they would not be a non-offending parent because of what's in the order. Again, once the child comes into care, I think placement would be made with a non-offending parent if they have paternity testing. Because that, again, that's a biological father that we know. They just don't, at the time, before the child comes into care, they don't have any rights at that point. Okay. When we're talking non-offending parent, so we've kind of talked a little bit about physical custody, but overall a non-offending parent is not the subject of the investigation, and they're not going to currently be living with the offending parent. They would like to have custody of the child, and they're willing to abide by the court orders on whatever type of contact the parent and the offending parent and the child are allowed to have. For more information on this issue, you may want to look at the policy on the non-offending parent. Let's talk a little bit about the prohibition on reunification and placement. In this particular statute, if the parent or someone living in the parent's home has a felony sex crime conviction from Missouri, where a victim was a child, then once the child is in state custody, the courts and the division are prohibited from placing or reunifying with that parent, or placing in that home as long as there's someone else in the home that has one of these convictions.
One thing that's important to remember in addition to that is, they might not have an actual conviction for something, but we also need to consider the facts of the case. If they have a preponderance of evidence for something, maybe like sexual abuse, just because they weren't convicted, we probably also need to consider that when we're looking at reunification. And
that's a good point. The chapters that are involved in here are felony sex offenses against the child, but there are other serious assault, attempted murder, and other type of crimes where it would not be appropriate to place the child. Okay. What we want to remember on the statute too is that the statutory prohibition applies on juvenile court cases that were filed on or after August 28th, 2004. And that would probably, most of our cases, the kids aren't in care that long, but if you have older children that you may be going back and looking at, are there any relatives for placement, you would want to take a look at what date they came into care to make sure whether or not this statute applies. So the case law on this area is still developing, and the important cases at this time are listed on the bottom of the slide. Again, the policy sets out very clearly all the listed offenses in the statute that you would need to be concerned with. And the recommendation, pretty much, if you think you have a parent who has, or another in the home that has one of these convictions, you probably want to send it by DLS and let them take a look at it. Do you think that would be a good idea, Christy?
I would agree with that.
Okay. Okay, we talked about the constitutional law and the various laws that would limit a fit parent's right to placement. So now we're going to move on to the federal laws that apply on relative placement. And again, we're still on the first page of the placement chart. And if you'll notice, you're going to see the Indian Child Welfare Act and sibling placement issues are at the bottom of the first page, placed next to each other. And that's because they're both federal law, and we would try to apply them to work together when looking at placement for a child. The Indian Child Welfare Act is federal law. The tribe has to be notified as provided by law, and the tribe's going to determine whether or not the child's an Indian. If it is an Indian child, then the child has to be placed where the Indian tribe requires.
One other thing that's really important is to make sure that we're documenting clearly that we've discussed with the parents whether or not they have any Indian heritage. Whether you document that in the opening summary of your case or just in a case contact, it's really important to make sure that that's documented somewhere in the record, not only in the court portion of the record, but in our record as well.
Don't you think, too, that if a parent says they have some Indian heritage and they have an identifiable tribe, you'd be trying to immediately contact the tribe to find out whether or not the child is placed?
Yes, based on the law, we need to be looking at those resources, and the Child Welfare Manual is really clear about the procedures that you need to go through in order to place through ICWA.
Okay. And clearly, Missouri law requires also that we comply with ICWA when it comes to the placement procedures. ICWA placement requirements, when you're talking relative, the tribe's going to define who the relative is based on their laws and customs. And if they don't, then we have some default definitions that would include grandparent, aunt or uncle, brother, sister, niece or nephew, first or second cousin, and step-parent.
So what if the tribe wants to make an out-of-state placement?
The tribe can do so, and ICPC does not apply. Again, they're a sovereign nation. So good point, though, Christy. Since you brought up the subject of ICPC, why don't we just discuss it a little bit, because it applies to relative placements, clearly. and placements preliminary to adoption. Do we have to place with relatives out of state if the goal is reunification, though?
Not necessarily, especially if ICWA does not apply. You need to consider all the factors of the case. Are you in the beginning stages of the case and reunification is still the goal? In that situation, it would probably be best to go ahead and do the home study request through ICPC, since we know that that can take a little bit of time, and then hold on to that for a period of time until we decide that maybe we're going to proceed with our concurrent goal and go ahead and place with the relatives. If we're at a situation in the case where the parents can't be located or they're not really working the plan anymore and we decide that we need a much more stable placement for the child, then in that point of the case it would be a good idea to go ahead and move the child out of state.
Okay. And I think that's a good point. Do you think the court would make a contrary to the welfare of the child finding? Not to place with a grandparent out of state just because the goal is reunification?
Yes, because it would be really difficult to work reunification with the parents if the child was placed out of state. You wouldn't be able to do the visitation near as well, and it's really hard, especially with a young child, to keep that bonding with the parents if the child's not in the same state.
And I think that's a very good point, and I agree with you. I think the courts would support a contrary to the welfare finding to place with a grandparent or other out-of-state relative when you're working very hard at reunification, and it would interfere with the parent's ability to visit and have contact and to demonstrate the changes they're making in order to parent. So, just a reminder that the ICPC Priority Home Study, basically part of the reason that this is so important is because it involves relatives for the most part, and it's the ability to get a child who spent substantial time in that placement's home, which is usually going to be a relative, and all of the siblings of that child to be able to get a priority home study to go to that state when it's needed. Just remember, when home studies have been approved, that they're good for 6 months. So again, that would be good concurrent planning to start early. Can you explain any more? How long does it take to get an ICPC approval?
It just depends on the case and the circumstances of the case. Obviously, the priority ones are going to go a lot quicker than the other ones, but sometimes it can take several months depending on how quickly the worker can make the referral to ICPC, and then for Missouri ICPC to contact the state ICPC where we're looking to do the home study.
Is it good concurrent planning if you wait until the year mark and the plan changes to a goal of adoption or guardianship to do the ICPC home study?
No, that's really poor planning on the part of the team. We need to make sure that we're making that kind of determination from the beginning. You know, the first 30 to 60 days is a really difficult time for the out-of-home worker because there's so much to do, but it's really important, you know, to be thinking about the child and the long-term plan, because we know that realistically we want all of our kids to be reunified with the parent, but we know that that just doesn't happen. So if we can be thinking about what we want, you know, for that permanent placement for the child from the beginning, then the case will be a lot more successful.
And that makes a lot of sense. Let's move on to sibling placements, because we've talked about parents' constitutional rights and we've talked about the federal law on Indian Child Welfare Act. Let's look at the federal law on sibling placements. The important thing is it requires the division to exercise reasonable efforts to place siblings removed from the home in the same placement. It sounds easy, but I think we all realize that this is turning out to be a lot more complicated than we thought. Part of the reason for that is that the feds do not define siblings, and it's not defined in state law either. But at a minimum, we know we're working to place siblings who were removed from the home together in the same placement. And the division has great policy on the importance of sibling placements.
So if I have 2 siblings that are in care, they're currently placed with relatives, and the mom has another baby, who should I place the new baby with?
Well, I think these are hard questions. I think you want to look at all the factors about the child, and you want to look at all the factors about the siblings, and you want to look to see if the other parent is fit first, and whether or not the child should be placed with that parent. But after that, aren't you going to look for, and you're going to rule out ICWA, that this isn't an Indian child. and then you're going to look and try to place that child with the other siblings, I think would be the best idea. What do you think?
Yes, I agree with that, and I think another thing that's really important is to make sure that you're documenting all this information in the case record. When we're reviewing records, it's really important to make sure that we are looking to see that we're trying to place with relatives, trying to place with siblings, depending on the case situation. You can't over-document for sure.
And actually, federal law requires that the division document all that information. So I don't believe there's any requirement that the court make findings on this, but the federal statute does require that the division document their files with the factual basis for the decision making. And it's not on whether or not it's in the best interest of the child. Actually, what you have to document is how it's contrary to the safety or well-being of any of the siblings.
Okay, so the court doesn't have to make contrary to the welfare finding. We can just document it in our record.
Yes.
Okay.
I think so. Well, what happens, Christy, if siblings are not placed together? If a finding's made that it's appropriate for sibling separation and somehow or other it's contrary to the welfare of the safety or well-being of any of the siblings, that we're going to split them, or they come into care initially and can't be placed together. What are we required to do?
Well, then we're required to look at grandparents for placement or other relatives if we cannot place with the grandparents, and we're required to make diligent efforts to try to place the children together in the same home unless it is contrary to the welfare and safety for them to be placed in the same home.
And if they're placed in different homes, are we required to try to work to keep that contact between the kids?
Yes, we should definitely be having ongoing visitation between the 2 children, 3 children, however many there are in the case, regular phone contact if regular in-person visitation cannot be done on a regular basis due to geographic location. They need to make sure that they maintain that connection.
And that policy matches up with the law on sibling placement that requires that. Also, if there's not going to be the sibling visitation or interaction, we're going to have documentation to show how it's contrary to their safety or well-being of any of the siblings, and that's required by law. Let's move on to the Missouri laws on relative placement. If you'll notice, grandparents are going to get first dibs, then there's other adult relatives. We'll talk about how prior foster parents, obviously they know the child, if the child's been in care before, would get preference if there's no relatives for placement. Policy deals with kinship, and then we have the regular foster parents who would be able to take children during emergency placement, and we'll talk about all of these. Basically, Missouri law gives preference to relatives over non-related caregivers once kids come into care. And the order these are placed in is probably the order in which the law looks at the placements when you look at it all in one big picture. What we have to remember is that although these are laws, again, you're going to look at all the facts, and if there's a contrary to the welfare finding that can be made, if you have a factual basis for it, then maybe the child won't go with a grandparent. Maybe they'll go with other relatives, or maybe they'll be prior foster parents, or another placement will take place. But you need to know what all the factual basis is in order to have that contrary to the welfare finding. The one thing about these relative placement laws is we're required now to do a diligent search to find these relatives, and then by federal law we have to notify the relatives that a child has come into care. And I think this is a paradigm shift for the division. It affects how we talk to parents about placing children with relatives, and it also affects confidentiality. I thought maybe, Christy, you could talk a little bit about parent engagement and how that's changed with the requirements on these relative placements.
Right. Well, engagement of parents in the placement process is really important. We want them to have a say to some degree in who they place with, but we know that we can't always do that. It just depends on the situation. They might want us to place with a relative who has a significant child abuse and neglect history, and we know that we can't do that. So one thing that's important is to explain to the parents that we might not be able to place with whomever they want us to, but what's important to explain to them is that we're required by law to place with relatives, and let them know that we might be making this decision to place with someone that they might not want us to.
And that's true. Sometimes do parents have good reasons not to want children placed with their relatives?
Sometimes they do. You know, I explained the significant criminal history or child abuse and neglect history. Maybe you have a mom who was in foster care as a child and we're looking to place with her parents and she doesn't want us to. And sometimes our families just don't want their extended families to be in their business. They don't think that they need to know what's going on. Maybe they're embarrassed to let their relatives know about what's going on with their particular child. So some of these are legitimate, but we also need to really look at the situation for the child. It's really best for a child to be placed in a stable home, preferably with relatives who can care for them long term, should that be what happens with the case.
One of the questions I get a lot in training is, what if the parent tells me that they don't want the child placed with their relative and then gives me some factual reasons for it? Do I have to take them at their word?
No, I think we need to look at the whole situation, but ultimately, you know, you're going to bring all that information to the family support team and decide on it together. You know, it should never be a decision where a worker's just making a decision on their own. They need to consider all the facts of the case and, you know, is it a situation where maybe the can history was dirty house, but this particular child's a teenager? If that's a situation, maybe that's a history that's not as important as something would be if it was sexual abuse or something more serious along those lines.
So if a parent presented some information, you would be checking with the relatives to try to rule that information in or out, present it to the team, and if necessary, take it to the court and let the court decide?
Yes, that would be correct.
And I think we have to protect our kids. So I think that's true. What about the confidentiality piece as far as looking for relatives? Do we have different conversations with people on how to find relatives?
Yes, one thing that you need to do is make sure that when you're talking to both of the parents that you're trying to ascertain all the information about who their relatives are on both sides of the case. You might also ask neighbors that are working with the family or other community providers that work with the family, anybody that you can talk to that might know. Even ask the children, you know, who would you want to be placed with, or do you have relatives that you know? Because we know sometimes at the beginning of the case it's a very difficult time for the family and they might not always want to disclose that information to us. And then when we take that information and we call the relatives that we want to place with, you know, it's important to tell them just briefly about that the child came into care. You don't need to go into a long conversation about all the details of the case and why they came into care, but also let them know that, you know, they have a right to placement based on the law, and let them know that there's support for them and their options with regards to subsidy should that be what happens long term with the case.
And I think that's very true, but I think this is a big change for workers. Hasn't the policy always been that we would not contact relatives unless the parents allowed us to?
And that's something that's kind of been local protocol in a lot of places. Some would say, you know, we want to be engaging with the family and we want to be family friendly, and if they don't want us to contact them, we shouldn't do that. So it's kind of been that back and forth debate between being family friendly and also doing what's best for the child.
But based on the current law, we have a diligent requirement to locate and place, and that trumps that confidentiality piece in terms of affirmatively going out and trying to find relatives and talking to whomever we need to, correct?
Yes, that's correct.
Okay. Now, let's move on to the individual relatives that are listed, and we're on page 2 of the relative placement chart hierarchies where we are. So grandparents are going to get first dibs under section 210-565. And the law requires the division to make diligent efforts to locate, contact, and place with the grandparents within 3 hours when an emergency placement is deemed necessary. I think one of the important things here to remember, that 3 hours seems like a very short time, but my experience has been, Christy, that in most cases, this isn't the first time we've seen that family. Is that true?
That's correct. You know, a lot of times we've had prior history with these families, so we can easily be going back to those old case records, looking at the genograms, talking with other people involved with the case, and finding out who those relatives are. You know, it's a difficult time when you're out with the family late at night and you you don't have a lot of options and it's just easier to call a foster home, but is it easier for the child to go with a stranger in the middle of the night when they're already scared of being removed from their home? No, nobody would want that. It's much better if you can locate those relatives, grandparents, whomever, and get the child placed with someone they know.
I absolutely agree, and I was telling Christy that in all the TPRs I ever did, I went back and read all the investigations and IAS cases and FCS cases, and there was always a great deal of information in there that's very, very, very useful regarding the parents and the relatives. And I think it points out from a legal perspective the importance of, during the investigation and assessment process, finding out who that other parent is, and using relatives when we're trying to do safety plans involving as much of the family as we can. And then those IAS and FCS services again would try to pull in relatives or pull in that other parent, and again that other parent would have relatives too. So the more information that we have and the good work we do on all these preventive cases to include the whole family will help us when the child comes into care and we're looking for relatives.
So what would I do if I have an adult sibling and a grandparent who both want placement of the child?
Well, again, these are never answers, are never easy, and there's no intent to give you a black and white answer to any of these questions. The most important thing is you'd want to have all the facts regarding the children that came into care and what their needs are, because a lot of times our kids have high needs, and when they have high needs, they require extra attention or help in the home that takes them in. My experience in these kind of cases would be that if you have an adult sibling, they're going to be a young adult in their early 20s, usually in an apartment, trying to make a living or going to school, and they probably, if you check, would not have all the resources necessary to place a couple of kids with them. Number one, as far as having enough room in the house. Secondly, depending upon how many jobs they work and their hours and their social life and their boyfriends and their roommates, that requires a lot of changes in their life to be able to provide the safety of these kids that we would require for placement. And again, just the financial ability and wherewithal to provide for the kids would probably be different. So more than likely the grandparents would have preference for placement.
Okay. So if I have both sets of maternal and paternal grandparents that want placement of the child, one thing that I should keep in mind to look at is all the factors again of the case. If we have this many options for relatives that want the child, you want to look at whether the child's bonded to one particular relative over another, the age of the child, the age of the grandparents, and their ability to actually care for the child. Does the child have special needs? All of those things need to be considered when making a decision, and ultimately what our job is to take all that information to the family support team and then let them decide.
Absolutely. And we can't forget too on where the school's located, depending upon if it's a school-age child. Sometimes you just need a map and to draw a picture of all of this to figure it out. We used this question in a training just recently, and one of the suggestions was the first thing that would be done would be to run a background check on all 4 sets of grandparents and start from there and make sure all 4 of them are going to pass the background, and then get all that information that you need. So either way, you have to have all the information. I don't think it's just about looking at the child and this second what's going on. What do you think, Christy?
I agree with that. Definitely, you need to look at all the factors. Another point, if you have a child that comes into care close to the summer, maybe like in May or something like that, and you have grandparents who live across the state, one thing you want to keep in mind is looking at all those factors when you're thinking about placing. This law talks about the 3-hour time frame. However, most of the laws have some kind of contrary to the welfare finding, and so if you think about it, if the child's maybe in middle school or something like that and it's May, you wouldn't really want to rip them from their school before the semester's over. It's probably best to let them finish out the year and then do the transition to the grandparents that summer. Now if it's a young child, obviously that transition can be done a lot quicker if there's not school issues, but it's important to consider all the factors related to the parents and the children and the grandparents.
Absolutely. And then again, the court making that contrary to the welfare finding would be great. And the documentation, just like the federal law, Missouri law requires these decisions to be documented, the factual basis to be documented in the division's files on how we handle this. One other thing, when we're talking about lots of grandparents for placement for a kid, there's nothing greater than having lots of people that want placement, lots of relatives that want placement. You know the child's loved, and there's the possibility of competing homes, especially grandparents. The law also provides that, like Christy said, the family support team wants to get all the information and make a decision on who they would recommend among competing grandparents. And the law specifically states you take that to the court and let the court decide. So like you said, the court will back you up in what you're doing as long as you have a factual basis. And one thing to remember too is the team members may not always agree, do they, Christy?
Oh, not always. You might have one that might want a certain and the other that might want something else. And especially when you get parents' attorneys involved, the dad's parent attorney would want with the paternal relatives, and maternal would want with her relatives.
And I think an important thing to do is to respect the other family support team members' positions. But just as a division, make sure we have a factual basis that supports our decision, that we're not just making a gut decision, that we've got some sort of factual basis. And again, the statute requires us to document it in our files, and that would be evidence to give the court to help the court make that decision. And if you're represented by DLS attorneys at the hearings, that will give them information on which to help present that information to the court, which would be really important. I thought your idea on moving the child during the school year was a great idea. Because sometimes, again, the court would probably make that contrary to the welfare finding to allow the child to finish out the school. So Christy's point is very well taken. There's some flexibility allowed in the law for all the factual basis, as long as you've got a good factual basis to help support your position is what it takes. You can't just say, oh, we don't want to do this. Have a reason for why you're wanting to do what you want to do. When we're talking about relative placements, the law supports that the court has to make specific findings that it's contrary to the child's best interest to be placed with a relative, and we need to be providing that information to the court. When we talk about relative placements, remember that relatives are defined within third degree of consanguinity, and you'll find that on page 3 of your relative placement chart, along with the child welfare manual talking about who's eligible for guardianship subsidies at this time. Because it makes sense, if you're going to place with a relative, the hopes would be that that relative would either be able to get adoption subsidy if the child could not be reunified, or guardianship subsidy if they meet the relative requirements. Lastly on the slide, there's a continuing obligation to make those diligent efforts to locate, identify, and place with a relative. If you take nothing else from this training, please remember that there's no expiration date on relative placements, and the child benefits greatly when we're looking for those relatives and trying to find them up front, because then you take care of those placement decisions and conflicts on the front of the end of the case. If we're not looking for the relatives, we're not finding them, and we're having problems, they will show up on the back end of the case when at the last minute relatives come out of the woodwork and want placement, and you may have had the child in a foster placement for a number of months. And this is kind of where you get into competing interests in the Missouri statutes, because the relative placement law has no expiration date. But in Chapter 453, a foster parent who's had placement for 9 months has what's considered a preference for placement for purposes of adoption. Now, the court ultimately will decide where the child is placed and who adopts the child. But these are problems that come up when we're not dealing with finding the relatives early on.
So that's probably something, if I have a situation like that where I have a child that's been in a certain foster home for a significant period of time, there's bonding there, and then relatives come out later, that'll be another case where I need to consider all the factors, right? The age of the child, the relationship of the child to the relative, and then ultimately let the court decide when we've presented all the facts.
Absolutely. And the thing to talk about there too is about when the child is not placed with a relative, all the way through the case, make sure you're notifying the court in the court report that you haven't been able to find these relatives, or they're refusing to take placement, and why. And then let the court make a finding on the record that it's contrary to the welfare of the child to be placed with the relative, because there's no appropriate relatives for placement and why they won't take the placement. Then when that relative shows up on the back end of the case at the 9 or 12-month mark and all of a sudden wants placement, it may help you again with all these other issues.
Right.
But it's all the facts, all the law, and the Children's Division alone does not have to shoulder the burden of proof on the relative placements. I think the courts need to be of some help, and those, if you can get a finding from the court, I really think those are important as you go through the case.
Definitely. And it's important to document on the child's CS1 all of the attempts to locate relatives. If you get to the point where you're looking at terminating parental rights, the court will want to know what efforts you've made to locate relatives, and doing case reads across the state, that's something that's definitely underutilized, is that section of the CS1. When you're doing case reads, it's really easy to be able to flip to that and say, oh, they did look for relatives, but they weren't appropriate, or yes, the child's currently placed with a relative.
While we're on the subject, are there reasons sometimes why the grandparents and other relatives don't want placement initially when it's offered to them?
Sometimes they don't feel like they could take care of the child. Maybe the child has significant behavioral and medical issues and they don't feel like they'd be able to take care of them. Some of them it's financial and they just don't think that they have the means to support the children, or they might live in a home where maybe they don't have a room for the child, because we have licensing standards that they'd still be required to meet with regards to safety. Now, some of the other licensing standards can be waived based on relatives, but ultimately safety is paramount. So if they don't have a means to support that child, then we want to look otherwise.
What if it's an issue, maybe not safety related? Well, it may be safety related, but what if and they don't pass the home study? There's an issue and they can't pass the home study. Do we just give them one shot at the apple, or should we give relatives more than one chance?
Well, not necessarily, because the child doesn't necessarily need to be in a licensed home. The court could order them to a particular placement, whether they are actually licensed or not. It just depends on the situation. So a lot of these, we'll be presenting all the information to the court and just letting them make a decision.
And I think an important thing to remember too is that our relatives of our families are probably in a lot of the same financial shape as our parents. So sometimes if there's a defect in the house or something that needs to be fixed, it may take them more than a couple months to get the money together to fix whatever needs to be fixed before before they could pass a home study. But is there any reason why we couldn't allow that relative to have contact and visitation and work on a relationship with the child in the meantime?
Right, definitely promoting that relationship, getting the visitation started, just like you would if you were transitioning a child from one foster home to the next. You want to be doing those pre-placement visits and letting them get to know each other so that the child will have a smooth adjustment to the new placement.
And what about talking to relatives? We need to be sure that we're explaining to relatives why it's important for them to take the placement early on in the case, right?
Yes, because if they decline at the beginning of the case, we can't really promise that, at the end of the case that we'll be able to, because then you run into the competing laws. The child might be in a current placement for 9 months, and then at that time you're looking at the preference for placement law versus the relative placement law, and it's a very difficult decision to make. So it's really important to get them involved from the beginning. It'll be much better for the child, both with stability and well-being.
And I think we've already had the conversation about confidentiality has changed because of these statutes, but when we're talking to that relative, we're going to explain the child's in care, but we're not necessarily going to violate any type of HIPAA laws relating to drug or alcohol or mental health issues or anything involve the parents. Basically, we're just going to explain the child's in care, and they can find out from the parents or others on why the child's really in care.
Yeah.
Okay.
Okay, so let's talk about a situation where we have multiple kids that come into care, and there are also competing placements available. These 3 particular kids that come into care all have the same mother, but they have 3 different dads. So who would I place with in this situation if there's also grandparents that want placement. Well, the law says that basically you need to look at placing with a fit parent first. So in this particular situation, if maybe only one of the parents is actually fit to care for the child, then we'd want to look at placing all 3 children with that fit parent, even though that parent isn't the biological parent to all 3. If, for instance, that parent only wants the child that's his, then we would look at the next law down, which is the sibling placement law, to keep those siblings together. So the best situation in that scenario would be to place those 2 siblings with maybe a grandparent on either side, maternal or paternal.
So what you're applying is, in that situation where the fit dad only wants his child, his constitutional rights would allow him that child, and then the other 2 children you would place together with a grandparent.
Yes.
Is that correct?
Yes.
Okay. That makes sense.
And then, of course, if you have the situation where they end up being split, for instance, the dad of the one child takes his child and then the other 2 siblings are placed with a relative, you'd want to make sure and maintain that visitation. You know, if you couldn't do it in person, make sure that you're doing phone contact, letters, anything like that to maintain that bond for them.
And that's a good point, because that's the other part of the sibling placement law, isn't it? That if you can't place together, you're going to continue to work on that relationship. That's true. Okay. Well, let's look at the other Missouri laws on placement regarding the child's preference for placement. And I think you'll find that on page 3 of the relative placement chart. Basically, the statute says the GAL needs to talk to the child and ascertain what their wishes are for placement. But that's not necessarily going to trump the relative placement preference, nor is it going to be considered the basis for a finding of contrary to the welfare of the child.
So what if I have a child who's 15 years old and he refuses to be placed with his grandparents? Does that trump the grandparents' right to placement?
No, it doesn't. You have to follow the law. The GAL is going to have to talk to the child and find out why. If there's an actual factual basis that would be support a contrary to the welfare finding, then the child would not have to go there. But without that, if it's just because the child doesn't want to go with that grandparent, that's not, the law does not say that that will trump the statutory preference, nor is it the basis for a contrary to the welfare finding.
So what if I have 2 siblings who want to go with different relatives?
Good luck. You're in the same shape. The same law applies. The GAL would have to talk to each of the 2 kids and find out why. And if there's no factual basis that would support a contrary to the welfare finding, then they're probably going to have to be placed together with the same relative. So, back to the slides. Let's take a look at kinship placement. The laws on relative placement don't talk about kinship at all. That's defined in policy, and we will try to follow that kinship placement when we don't have relatives that will meet the for the placement. The only other thing that would trump that kinship placement is if the child's been in care before and there's a prior foster parent that knows the child. So once you get through all those laws on the relatives and you're looking at foster parents and kinship placement, again, we're still trying to look at somebody for placement that knows the child. Mm-hmm. If the child's been in care before, they're going to know a prior foster parent. That you would try for that placement. If that placement doesn't work, then you could look at the kinship placements where they're not related.
And that's kind of tricky too, because I know some people think, you know, well, the neighbor who knows the child, who saw the child yesterday, should get preference over a foster parent who hasn't really been involved with the child for over a year or something like that. So that's an important point to note, that that's a little different than what most people would think.
Yes, and that's in the law. If you look at the foster parent piece on this, you will see that cited in the law. Lastly, the foster parent placement. Clearly, on the front end of a case, if it's an emergency placement and we can't locate grandparents or other relatives within that 3-hour time period, we can go ahead and place with foster parents. But the law still requires a diligent search for relatives for placement. We can't just quit with the foster parent. We have to continue to do that. In one of the alternative care trainings that I did in the last few months, one of the circuit managers said that she and her staff have kind of changed the way they look at this relative placement piece. So even if the child is placed with foster parents, they're going to talk about how the concurrent plan is either going to be adoption or guardianship with a relative. And they're going to make it clear to the foster parents that they're continuing to work and look for relatives until they're all ruled out. And before they would change the concurrent plan or look at a relative for the concurrent, I mean not a relative, but a foster parent for the concurrent plan.
And that's a really good plan to have, because so often we place our kids in foster homes and they immediately think that, oh, that I'm going to get to adopt this child, especially if it's a young infant. And we want to make it clear throughout the life of the case that, you know, our concurrent plan is going to be with relatives until they're all ruled out. And if that's the case, then we at that time will look at the foster parent as our concurrent plan.
And I think, you know, it really is important. You're right. I think it means the conversations the workers have with the parents needs to be more than once on why kids need to be placed with relatives. The conversations we have with relatives need to be more than once on why they need to take the placement when it's offered and why. And then the conversation also needs to be had more than once with the foster parent that the concurrent plan will be adoption or guardianship with relatives until we've ruled the relatives out. And that is probably fair to everybody. And then, of course, we're back to that D word, which is we want to document all those different conversations. Because from a legal standpoint, when things get sticky at the end of the case and everybody's wanting placement or wanting adoption or whatever for the adoption staffing, we would have evidence to support our position because we've documented all the different times we had these conversations. We put it in our court reports. We've had multiple conversations with them, asked the court to make a contrary to the welfare finding. And then all of that will make it a little easier, if it's possible to make it easier, on the back end when you end up in competing relationships. Lastly, I think on the law section, because then we're going to talk about factors, right? Mm-hmm. All the facts that are involved in the case. But lastly, on the law section, we're going to talk about the federal notification statute. It's really important. And again, it's good concurrent planning because if you notify, as required by federal law, all the adult grandparents and other adult relatives of the child within 30 days that the child has come into care, then you're going to have all those relatives on the front end of the case to deal with them. Now, there's an exception for family or domestic violence, and I don't believe it's explained any better than that. But I think what you're looking at are safety issues. You know, if there's information you're not wanting to provide for a relative because of family or domestic violence issues. But those notification requirements, I think you probably mentioned them just as we've had this conversation throughout this training, that the notification requirements are the child's been removed from the parent's custody without going into a lot of detail, the explanation of the federal and state laws regarding the placement and options lost if they don't respond and take the placement when it's available. The fact we have to notify these relatives of the ability to foster and what services are available during that period of time, and also for the availability of relative subsidy for guardianship. So that's all involved in the notification piece.
Okay, well now let's take a look at the factors a little bit more closely. We have a child who was removed from his mother. The father cannot be located. The mother's parents are divorced and remarried. The father's parents are divorced and remarried. All 4 sets of grandparents want the child for placement. All 4 sets of grandparents have passed criminal history checks, CAN checks, and walkthroughs of the home. Now, what would I do? Where should I place the child? Well, one thing that's important is to consider all the factors, and we've talked about that throughout the whole training. The factors related to the child should be considered first. The age of the child, the culture and race of the child, if the child's more bonded to one set of grandparents than the other, if the child has behavioral and medical issues. Obviously, if there's significant issues, you want to make sure that you place with a relative who is capable of working with those behaviors. The next thing you want to look at is the factors surrounding the fit parent. In this case, we already explained that we can't find the parent, but we're required to continue to look for that parent throughout the life of the case. You'd also want to look at the siblings. Were they removed together? Have they lived together? Have they ever been adopted? The relationship between the siblings. All that stuff needs to be considered. And then finally, the relatives, the background checks, the location of the relatives. We've talked about that. You know, if your goal is reunification, which most times it is at the beginning of the case, you'd want to place with relatives who are close to where the reunification source lives. Is the relative equipped to handle the child? What's the relative's commitment level to the child? Are they thinking that they just want to keep the child for a few months and then mom will get the child back? We really want to place with relatives who are able to think long term, because we know that sometimes reunification doesn't happen and these cases need to be more long term. So we want to make sure that we get a relative who's really committed to working with that child.
So Christy, my question to you is, does it really matter how far the apple falls from the tree?
No, it really doesn't. Safety and well-being of the child are paramount. You need to make sure and look at all the factors of the case and make an informed decision.
Well, that's the end of the training. I'd like to thank Christy for her help today and thank all of you for your participation.